Good evening, Mr. Michalowski, classmates, and guests. The case I'm going to present tonight is purely fictional. Any similarities are coincidental and should not be used when formulating an opinion about residential care facilities. I currently work in an assisted living community that employs 12 housekeepers on 2 floors covering 160 residence rooms. Before the housekeepers begin their duties, they're supposed to put on shoe coverings, gloves, and disposable 3/4 length button-up protective smocks. After donning, which can take from 5 to 6 minutes, the employee is supposed to clock in and begin their shift. After their shift is complete, they're supposed to clock out and remove all protective coverings, which can take another 3 to 5 minutes, and dispose of them in proper containers. The law tells us that the preparatory activity should be counted as time worked since the employee is subject to employer control and are suffered or permitted to work. The law also states that in a non-union workplace, employees must generally be compensated under both the FLSA and California law for time spent donning and doffing certain work clothes and protective equipment. If the time spent changing into and out of clothes occurs regularly and is part of the work the employee was hired to do, the best practice is to count the time. Furthermore, the law states that small amounts of time spent changing into and out of clothes may be disregarded in certain situations when these small periods of time are uncertain and infrequent and cannot, as a practical matter, be precisely recorded for payroll purposes. My concern is that the company could face a wages and hours class action lawsuit. A total of 20 to 30 minutes a week per employee is not being computed into their wages. Some employees have been there full time for more than 5 years. It could get ugly expensive. My recommendation: notify the housekeepers that modifications in company policy now state that protective coverings shall be put on and removed while on the clock. I would also compensate the employees instead of going to court. My reasoning? I'd like to refer to the case of Sandifer v. United States Steel Corporation, where on January 27, 2014, the United States Supreme Court found that the FLSA did not require an employer to pay workers for time spent donning and doffing protective gear in a unionized workplace because the decision must be reached through a collective bargaining agreement. However, the court held that the term clothes includes all items designed and used to cover the body and are commonly regarded as articles of dress. The court also stated that just because the item is worn for protection, it is not excluded from the definition of clothes. Because the employer willfully neglected to compensate the employees for changing time, punitive damages would not only be costly, it could damage the reputation of the company if they were to go to trial. The time and money spent on litigation would equal more than the compensation of the employees. Thus, by definition of the law, in a non-unionized establishment, I believe that if the organization was brought before the courts, the public humiliation and monetary considerations would not be favorable to the plaintiffs. Thank you.